of a civil suit. The following are the 9 different stages in the progress of suit from the time of the institution to the end. Number 1. Institution of a suit. A civil action started by filing a plaint which contains concise statement of the plaintiff's claim, the grounds upon in respect of which he seeks assistance of the court, the relief in respect of which he seeks assistance of the court. It is made up of 3 parts, namely the heading and title, the body of the plaint, the relief claimed. Number 2. Issue and service of summons. After the plaint has been registered, summons may be issued to the defendant to appear and answer the claim on the day to be specified therein. Section 27, Order 5, Rule 1. Number 3. Defense of written statement. According to amended law, the defendant is under obligation to present a written statement of his defense within 30 days from the date of service of summon on him. Order 8, Rule 1. Prior to it, he could file the same at the first hearing or before the first hearing or within such time as the court might permit. It has also been added that if the defendant fails to file the written statement within 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing. However, the amendment also makes it clear that such period of time shall not be later than 90 days from the date of service of summons. Just as civil action commences by the presentation of a plaint, a defense usually starts by putting in a written statement. Whether the defendant relies on any document in support of his defense or claim for set-off or counter-claim, he shall enter such documents in a list and shall annex the list to the written statement. Order 8, Rule 2. Effect of appearance and non-appearance of parties. At the call of the suit, if neither of the parties are present, the court may dismiss the suit. But where the plaintiff is present and defendant does not appear, the court may proceed ex parte and pass an ex parte order. Order 9, Rule 6. Number 4. Discovery. Every party to a suit is entitled to know the nature of his apparent case, so that he may be able to put forth a proper reply to it. If the pleadings are not clear and do not disclose the real state of affairs, if there is some ambiguity, a party is entitled to obtain further information from the other party by serving interrogatories. Discovery means to disclose all material facts which constitute a case and all cases necessary to support his opponent's case. Number 5. Settlement of issues. After filing of written statement, the stage is raised in a suit when the court is in a position to find out the real question in controversy between the parties. If the court finds that the parties are not at issue on any question of law or fact, it may at once pronounce the judgment. If the court finds that pleadings are not clear on certain points, it may examine the parties. Trial. Number 6. Trial. The trial of a case begins with the production of evidence by the parties to the suit in support of their claim or defense, in order to enable the court to arrive at a conclusion with respect to the issues involved in the case. Evidence means and includes: number 1. All statements which the court permits or requires to be made before it or by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. Number 2. All documents procured for inspection of the court. Such documents are called documentary evidence. The plaintiff then generally begins the case by examining his witnesses in support of the issues. Then the defendant cross-examines the plaintiff's witnesses. After plaintiff's evidence, defendant's evidence begins. After the parties have adduced all evidence and closed their case, the counsels on both the sides may address the court. The parties beginning the case will argue first, and the other party thereafter, and the party beginning will have a right of reply. Judgment. The court, after the case has been heard, shall pronounce judgment in open court, either at once or on some future date, of which due notice shall be given to the parties or their pleaders. Order 20, Rule 1. Where a judgment is not pronounced within 30 days from the date on which the hearing of the case was concluded, the court shall record the reasons for such delay and shall fix a future day on which judgment will be pronounced, and due notice of the day so fixed shall be given to the parties or their pleaders. Decree. Number 8. After the judgment is pronounced, the successful party applies to the court for drawing up of the decree, which is drawn up by an officer of the court. The decree shall agree with the judgment. Execution. It is the enforcement by the process of the court of its own decrees and order. It is the final stage of the suit. That is, execution is the final stage of the suit. The successful party makes an execution application for enforcement of the decree. Thank you.